look to Justice Jackson's framework. And he said that he divided cases in this area into three categories: where the president acts with explicit or implicit congressional approval, where the president acts and Congress has not expressed its view on the matter one way or the other, and the final category where the president exercises executive power and Congress, and that is in the face of an explicit or implicit congressional opposition to it. And depending on how one works through the statutory issue, then the case might fall into one of those three areas. I think the first thing that has to be said is what I said yesterday, and that is that no person in this country is above the law, and that includes the president and it includes the Supreme Court. Everybody has to follow the law, and that means the Constitution of the United States, and it means the laws that are enacted under the Constitution of the United States. Now, there are questions that arise concerning executive powers, and then those specific questions have to be resolved, I think, by looking to that framework that Justice Jackson set out. And if a question came up of that nature, then I think you'd be in where the president is exercising executive power in the face of a contrary expression of congressional will through a statute, or even an implicit expression of congressional will. You'd be in what Justice Jackson called the twilight zone, where the president's power is at its lowest point. And I think you'd have to look at the specifics of the situation. These are the gravest sort of constitutional questions that come up, and very often they don't make their way to the judiciary, or they're not resolved by the judiciary. They're resolved by the other branches of the government. But what I'm saying is that sometimes issues of executive power arise, and they have to be analyzed under the framework that Justice Jackson set out. And you do get cases that are in this twilight zone, and they have to be decided when they come up based on the specifics of the situation.
Murder somebody and escape prosecution, or immunize the person from prosecution, absent a presidential pardon? Neither
the president nor anybody else, I think, can authorize someone to override a statute that is constitutional. And I think you're in this area when you're in the third category under Justice Jackson. That's the issue that you're grappling with. I think that puts us in that third category that Justice Jackson outlined, the twilight zone, where, according to Justice Jackson, the president has whatever constitutional powers he possesses under Article 2, minus what is taken away by whatever Congress has done, by an implicit expression of opposition or the enactment of a statute. And to go beyond that point, I think we need to know the specifics of the case. We need to know the constitutional power that the president, the type of executive power the president is asserting, and the situation in which it's being asserted, and exactly what Congress has done. And let's issue about the meaning of the authorization of the use of military force. How far was that intended to go? And so the statutory question, I think, would be an issue that could come up in this situation, and probably you would need to, I think you would have to resolve the statutory question before you could figure out which of the three categories that Justice Jackson set out the case fell into.
But just on Hamdi, that has been decided. Would you say that Justice O'Connor basically applied the Jackson test, not the twilight zone test, but the test of where the president's power is at its lowest ebb?
In addressing the statutory question, I don't think she had any need to get into Justice Jackson's framework as well.
But would you say it would be consistent with what Justice Jackson said?
I think it certainly is consistent with what Justice Jackson said.
Which decision do you personally agree with, hers or the dissent by Justice Thomas?
I think that the war powers are divided between the executive branch and the Congress. I think that's a starting point to look at in this area. The president is the commander-in-chief, and he has authority in the area of foreign affairs and is recognized in Supreme Court decisions as the sole organ of the country in conducting foreign affairs. If it was determined that there was statutory authorization, then I don't know what the constitutional issue would.
But that there wasn't?
Well, there would still potentially be, there might be a constitutional issue. Let me stop there. There would be a Fourth Amendment issue, obviously. If you went beyond, if you determined that there wasn't statutory authorization, then as far as whether, then as far as the issue of presidential power is concerned, you would be in Justice Jackson's scheme, and you would, in the category where the president, you'd have to determine if this is the argument that's made, whether the president's power, inherent powers, the powers given to the president under Article 2, are sufficient, even taking away congressional authorization, the area where the president is asserting a power to do something in the face of an explicit congressional determination to the contrary.
Now, in my lay mind, the way I interpret that, and correct me if I'm wrong, is that you essentially have a conflict, and that it hasn't been decided whether one trumps the other.
I think that's close to the point that I was trying to make. The way Justice Jackson described it was that you have whatever executive power the president has minus what Congress has taken away by enacting the statute.
Even though you have a statutory prohibition, even a criminal prohibition?
Well, I'm not suggesting how the determination would come out. I think it's that it is implicit in the way Justice Jackson outlined this that presidential, well, he said it expressly, presidential power is at its lowest in this situation, where the president is claiming the authority to do something that Congress has prohibited.